Hi there, how are you doing today? My name is Mutiaba Conrad. I'm a lawyer and a private law tutor. And today we are basically going to be looking at the offense of attempted murder. But however, before we start our class, I encourage you to subscribe, like, and share this channel, and also ensure that you turn on the notification so that you're able to always receive information when new classes are released on your channel. And then for students that also require private law tutorial classes at school in holidays, you can always involve the experts and you can always come in and give you a detailed, more personal touch and guidance in your academic endeavors. Grades really matter, so please ensure that you have the best grades in law school, because this will really determine the future of your career. So let's proceed on right away to look at this offense. And in this class, basically, we're going to be looking at a number of aspects, including the ingredients of the offense. We'll also attempt to define what this offense is. We'll also look at the position of the law. What does the law say on the offense of attempted murder? We'll also, among others, evaluate in detail these ingredients and what they really mean. And in so doing, we'll be evaluating a number of case law, and we'll also be looking at the punishment of attempted murder. So let's proceed right away with the definition. But before we go to the definition, I think let's start with laying down the law. And I invite you to look at section 204 A and B of the Penal Code Act. It provides for the offense of attempted murder. The definition, please, for purposes of the definition, basically this, when we talk of attempted murder, what we mean here is that this is basically the failed or aborted attempt to murder another person, and it consists of both action and intention. Okay, so again, for someone to be convicted for attempted murder, there must be both the actus reus and the mens rea of the offense. This is really very important. Now, that definition was clearly provided for in the case of Uganda versus Mwanga. It is CS case number 456 of 2018. You can find all these cases on online, specifically on ULI, for your personal private research. Let's now proceed to look at the ingredients of attempted murder, and these were also clearly laid down in the case of Uganda versus Mwanga, and these include, for starters, the first ingredient of attempted murder is the unlawful intention to cause death. And then also, secondly, the second ingredient is an overt act manifesting that intention. And then thirdly, the accused committed the offense or participated in its commission. And then lastly, which is ingredient number 4, where there is more than one accused person, that there was a common intention to execute an unlawful purpose. Now, this fourth ingredient only comes in where there is more than one accused person. Also important to note, these ingredients can also clearly be found under section 204 part A of the Penal Code Act. That's where these ingredients are extracted. Let's now proceed. We'll be evaluating these ingredients a little bit more, but now let's proceed to look at the punishment of attempted murder, and this is basically life imprisonment. Again, that is under section 204 of the Penal Code Act. So let's now proceed to analyze and evaluate these ingredients a little bit more in detail. And the first ingredient, we actually going to look at the first and second ingredient together at once, because they are actually both related to each other and quite predominantly similar. So the first ingredient, which we summarized just a few seconds ago, is the unlawful intention to cause death. We are going to look at that ingredient together with the second one, which is an overt act manifesting that intention to cause death. So we are looking at ingredient 1 and ingredient 2 simultaneously, because they are more or less related to each other. So for purposes of those ingredients, I encourage you to look at the case of Uganda versus Mwanga and another, that case that I already cited for you. It's very, very authoritative on the ingredients. And in this case, basically, court held that there must be an overt act manifesting the intention. There always must be an overt act. And remember, we already said that an overt act is an act that is very, very close to the act. So there must always be that overt act. And direct act was also defined in that case as an act directed towards another person that indicates an intent to kill or harm and that justifies self-defense. Also refer to the Merriam-Webster Legal Dictionary. It will also be very helpful on the same. Also, the other interesting holding in that case of Uganda versus Mwanga, court held that stabbing anyone with an instrument capable of causing death is sufficient to prove the intent to kill. So basically here what we mean when we are looking at an intention to kill, the intent to cause death, okay, the act that you actually even attempt to kill someone, it is immaterial, okay, that they actually died, okay. But here what we are saying that the moment you attempt, you remove a gun and you attempt to shoot someone, and maybe for some luck they survive, but the moment you show that intention, okay, you remove let's say a knife, you stab someone with any other instrument, could be a knife, maybe you use a panga or a gun or anything, any dangerous instrument is in itself sufficient to show that you indeed intended to kill this person. Also of interest is the case of People versus McDavis. It's a case of 97 AD 2 stroke 302. In this case, court held that one may harbor at the same time both an intent to cause serious physical injury and an intent to cause death. So these intentions can actually be borne by the accused person at the same time. They may actually intend to kill the complainant, they may have intended to kill them, but it's also possible that actually they also harbored an intention to seriously injure these persons, and all those intentions will point always to the aspect of an intent to kill. So basically that is it. Then as regards the overt act, the accused person must have done an act very close to actually the main act, assuming you point a pistol at party B and you shoot them, but however, maybe in them trying to run or to jump, maybe you miss their heart, and then maybe the bullet hits maybe the arm, and in so doing they survive. So you realize that that is an overt act. The act of shooting their arm is very close to the act of actually shooting their chest or their heart that could actually have ended their life. So any action that is very close to the main action will actually amount to an overt act. Assuming you attempted to attack someone with a panga, and then in trying to throw the panga, maybe such a person dodged it, or maybe they tried to do something and the panga hit another object and they survived in that way. That act of trying to throw the panga towards someone's face can legally be interpreted as an act which is of an overt nature. Let's now proceed to look at the third ingredient a little bit more in detail, and the third ingredient is that the accused participated or committed the offense. As I've always told you from the very beginning, it's always very important to put an accused person at the scene of crime. You must always create that chain to show the continuity that all these things were committed, but however it is the accused person and no any other person committed them. Because remember, offenses that are criminal are of a personal nature. Okay, so you have to always link the accused person to the commission of the crime. Should you fail, then you will always never get a criminal conviction from court. So you always have to show the participation of an accused person. And here, careful examination of evidence is required. You have to ensure that you carefully examine the evidence to show that actually the accused person is part. And the general rule, okay, the general rule as laid down in the case of Search Toreko versus Uganda, case of 1967, East Africa, page 531, and also the case of Kato versus Uganda, it's a case of 2002, volume 1, East Africa, page 101, is as follows. The general rule pertaining to the third ingredient, which is that the accused participated or committed the offense. So the general rule was laid down in those two Supreme Court decisions that I've given you, and the general rule is as follows, that an accused person doesn't bear the burden to prove his innocence. So this is very important in criminal matters. An accused person never has the burden to prove their innocence. No, the burden is always on prosecution. The burden is always on state. Very, very important to note. And that by putting forward the defense like an alibi or an alibi, as some people prefer to call it, that alibi if an accused person puts it up, okay, we'll be looking at defenses a little bit more in detail, but an alibi simply means that I was not present at the time of the commission of the offense. So if the accused person puts forward a defense like an alibi or any other defense, an accused doesn't assume the burden of proving, okay? They don't assume the burden of proving the defense. No, the burden is not on them. The burden is always on prosecution to put such an accused person on the scene of crime and show that whereas the accused person is saying that they were not there at the time the offense was committed, however, your lordship, the accused person was at the scene of crime. You must lead evidence, okay, during a trial to show that in fact this person was at the scene of crime and that the alibi does not suffice, and as such it is not tenable, except there are the exceptions, except in a few exceptional cases provided by law. Okay, so there are few exceptional cases that are provided by law, which will also be looking at it. Now, it's also important to note that it is up to the prosecution to disapprove the defense of the accused person. It is prosecution to dismantle, okay, and unpack that defense that has been put up by the accused person or persons if there are more than one, by adducing evidence that shows that despite the defense that has been put up by the accused person, the offense was committed by the accused. I've shared with you a number of cases, and I'm also going to add you another case of Wamala and Another versus Republic. It's a case of 1999, Volume 2, East Africa, page 358. Please go and look at it. It is what actually lays down the principle that the moment an accused person puts up their defense, okay, the burden is on prosecution to dismantle that defense by showing that in fact the accused person at the material time of committing the offense, he or she was squarely at the scene of crime. This can be done by leading evidence to show. You can lead evidence of hair samples, okay, evidence, any sort of evidence of eyewitnesses, okay, camera evidence. You can lead evidence of a sniffer dog to show that in fact at the time of commission of the offense, the accused person was squarely at the scene of the crime. This is extremely important. So ladies and gentlemen, that was all for today, and I encourage you once again to subscribe to my channel, also like and share these videos, and also ensure that you turn on the notification bell. And for students once again interested in private law tutorial sessions for your own publishing, for your own guidance, you may need that mentorship. You really need it for you to be able to emerge as top student. Please always feel free to contact us. Our contact is down in the description box. You can always contact us, and then we see how we can make private arrangements for the same. Thank you very much, and we'll be meeting in another class. Bye-bye.